welcome back. This is our second panel of the day titled Environmental Regulation, a Case Study in Reform. Obviously, I'm not Professor Caroline Seacott. She fell ill, caught something from her kids, and so you're stuck with me again. I'm pinch hitting for this panel as well. But it's my pleasure to be here for this panel because I've been looking forward to this conversation. We have a paper written, co-written by two of our panelists, Emily Hammond and Rob GLICKSMAN. They will jointly present the paper, and then we'll have commentary from David Rivkin and Ashley Parrish, who I'll introduce when we get to that point. First, let me introduce the authors. Emily Hammond is the Glenn Earl Weston Research Professor at the George Washington University Law School, where she teaches and writes on energy law, environmental law, and administrative law. As you can see in her bio in the program, she's a former environmental engineer. And so she brings genuine technical fluency to cutting-edge issues at the intersection of law, science, and policy. She's the co-author of Environmental Protection, Law and Policy, and also co-author of Energy, Economics, and the Environment. Her co-author and co-presenter today is Robert GLICKSMAN. Rob is the J.B. and Maurice C. Shapiro Professor of Environmental Law at the George Washington University Law School, where he teaches and writes on environmental law, natural resources law, administrative law, and property law. He is the author or co-author of many books and articles, including the aforementioned Environmental Protection, Law, and Policy, which is the 8th edition of which will be published next year. Emily and Rob, thank you very much for joining us. I'll let you two present together however you see fit.
I think we will use the podium to get started here.
Okay.
All right, Adam, thanks very much for having us, and to everybody who's here today, and our discussants as well. I'm glad that this panel follows the prior one. I think that some of the matters alluded to in the prior discussion flow very naturally into our topic, which is a paper that is trying to discern the lessons to be learned from the emerging body of law that's coming from the courts as they review the Trump administration's activities, and what we see as widespread violations of core administrative law requirements. So I'll say a few words about terminology, and in particular our title, before giving some examples, and then Rob will turn to the matter of remedies. So first of all, our paper, The Administrative Law of Regulatory Slop and Strategy. When we presented this work in progress at an earlier panel leading up to this one, we did get some pushback on this idea of regulatory slop in particular, and questions about what we meant by it. So we see several possible explanations for widespread violations of administrative law principles, and they're these. First of all, we may see purposeful disregard of procedural and substantive requirements that otherwise would be lending legitimacy to agency actions. We may also see willful ignorance of these kinds of requirements. On the other hand, some ignorance may be excusable, attributable to new officials in the agencies who, as we saw in that prior panel, lack government experience and are simply unaware, at least in the beginning, of core administrative law principles. And then a wide body of what all presidents do is to push the law in furtherance of their political or their policy preferences. Reasonable efforts to push those boundaries in a particular direction. So we see those first two, that is the purposeful disregard and the willful ignorance of administrative law requirements, as being of great concern for the rule of law. And these are in particular are what we mean by regulatory slop. The last one, those reasonable efforts to push in a particular policy direction, we see as strategy. And so that's what we mean by that portion of our title. So in our paper, we indeed take the position that many of the actions we're seeing reviewed are slop. This stems from our assessment independently of the merits, the judicial evaluation of the merits, and our consideration of some of the court's rhetorical choices, how they use the language and what they actually say about what the agencies are doing. We argue that the courts must insist, and largely are insisting, on adherence to those legitimizing procedures and reason giving, and a key way to bolster that insistence is through strong use of the remedial authorities that courts have available to them. So I'll say a few things about our typology of slop, and just give a few brief examples. There are many more in our paper, and I'm sure we can discuss a number of them as well in the comments. The first one, and this is one that we've seen in scores of agency actions, is improperly suspending effective or compliance dates in existing regulations. This is perhaps the most clear-cut flouting of those administrative law principles, because the general rule is that such dates are part of the regulation. And so if an agency wants to change them, they have to go back through notice and comment rulemaking to do so, and they have to justify the change. But what we've seen, certainly in the first year and a half or so of the administration's efforts, is widespread attempts to improperly suspend those effective or compliance dates. So for example, in California versus Bureau of Land Management, a variety of tribal and citizen groups challenged the Bureau of Land Management's postponement of compliance dates for an Obama-era waste prevention rule having to do with wasting natural gas on federal lands. This postponement did come following an executive order. This is President Trump's Energy Independence Executive Order, which instructed the agencies to review rules with the aim of reducing any regulatory burdens on domestic energy sources. In its notice announcing the postponement, the BLM explained that it was invoking Section 705 of the APA to preserve the status quo while that Obama-era waste prevention rule was undergoing judicial review itself. The court rejected this explanation. It said it was contrary to the language of the APA, and it also rejected BLM's argument, which was its only real argument, that it wanted to promote regulatory certainty during this period of judicial review of the Obama-era regulation. And the court said, look, that's not a good enough reason. And in particular, the court emphasized that the agency was actually undermining regulatory certainty by trying to change compliance dates without going through the proper procedures. Turning to the remedy, the court did vacate that postponement notice, and it emphasized that doing otherwise would be viewed as a quote, free pass for agencies to exceed their statutory authority and ignore their legal obligations under the APA, making a mockery of the statute. That's pretty strong rhetoric. And we see lots of examples like that, particularly in these postponement of effective date type cases. A number of other decisions involve the agency's failure to provide notice and comment. Of course, we know that those requirements are generally applicable unless otherwise specified by statute, and in particular, unless the agency action falls within a specific exemption from that process. Early efforts by the Trump administration to rely on those kinds of exemptions have largely failed. So for example, in California versus Department of Health and Human Services, plaintiff states challenged 2 interim final rules that would have exempted certain entities from complying with the Affordable Care Act's mandate that employers provide insurance for contraceptives. The agencies relied on the good cause exemption in the APA, saying that they were justified in foregoing notice and comment because, there were other pending lawsuits on this very matter under Obama-era rules. So the court, once again, it rejected these arguments. It said the defendants simply hadn't shown why they couldn't achieve their objectives by going through notice and comment. In particular, the court emphasized that notice and comment was necessary and important because the new rules directly repudiated what the prior administration had done. And the court emphasized that that was well documented and well substantiated prior positions. Here, the court imposed a preliminary injunction against the agency's use of its new rules, and it also imposed that nationwide. It reasoned that that was appropriate. Rob will say a few more words about nationwide injunctions generally, but I just want to give this concrete example where we see one. Finally, and this of course is a large category of what we see in administrative law generally, is that of failing to make the required findings that an agency must make. This, of course, is consistent with the principle that agencies have to engage in reason giving. They have to support their decisions with facts and analysis. And of course, it's permissible to change policy with new administrations, but agencies have to explain why, and those explanations have to be in conformance with the statute. Some of our examples, we think, fit the label slop because they fail to provide even a rudimentary analysis. We do notice some examples, we collect these in our paper as well, that are probably much more strategic. Simply agencies that have created records, courts may have found flaws in them, but it's not a flaw that we feel comfortable saying is anything more than ordinary administrative law as opposed to something like slop. So let me give you a couple of slop examples since that's our focus. In League of United Latin American Citizens versus Wheeler, EPA issued an order denying a petition to revoke pesticide tolerances for a particular pesticide on food products. This is despite the agency's own significant record supporting safety concerns about this pesticide, and the court held that EPA's action here was arbitrary and capricious. It did not refute its own previous scientific findings or conclusions that this pesticide tolerance violated the statutory standard. And instead, the agency just said, we need to do further research. The court held, in fact, said it's time to put a stop to this statutory evasion. Again, very strong language that we think supports our characterization of slop. I also wanted to mention the Keystone XL pipeline decision that recently came out. Here, the Trump administration attempted to undo the Obama State Department's denial of a permit for the pipeline. That prior denial had been based heavily, I should say, on concerns about the pipeline's impact on climate change. Here, the court said, yes, the Trump administration has the authority to put more weight on energy security than the prior State Department did, but it didn't make its policy shift in such a way that it explained why the prior record wasn't as important anymore. In fact, the court said it ignored an entire section of the record of that prior decision that had considered climate change and foreign policy. And the agency failed to provide any explanation at all why it completely ignored that major part of the prior record. So here, the agency, as the court said, made a conclusory statement that action on climate change was not critical, and the court said this falls short of a factually based determination, let alone a reasoned explanation. The State Department had simply discarded prior factual findings, and so the court remanded its approval of the project. Again, here, this is fairly blatant. Agencies ought to know that they need to explain prior records, especially the central component of prior records, which is what we had in this particular example. And so we think that also qualifies as slop in comparison to the run-of-the-mill strategic kind of decision-making that sometimes doesn't survive judicial review. So I'll pause there and have Rob take over to discuss remedies.
Thank you.
Thanks for setting this up for me, Emily. So the first half of our paper describes why we think that agencies and how agencies have deviated from established administrative law norms. Second half of our paper asks what remedies are needed to ensure that agencies understand that they have more to lose by ignoring basic administrative law norms than they gain in expeditious pursuit of deregulatory and other substantive agendas. And as Emily began to explain, the courts too have expressed the same concern. She provided us with an example of the BLM's waste prevention rule. I just want to quote one further portion of the court's opinion in that case in refusing to allow the agency to suspend a prior Obama administration rule without undergoing further notice and common procedures. The court said, that the BLM's rulemaking strategy was intended to dramatically reduce and even eliminate public participation in the decision-making process. And I think that was one of the reasons the court was so upset. There are other cases of similar ilk. There's a Clean Air Act case on chemical disaster management in which the court also said that EPA's procedural approach made a mockery of statutory procedures. And third, there's a Clean Water Act case decided recently, which the court stated that to allow the type of administrative evasiveness that the agencies demonstrated in implementing yet another suspension rule would allow government to become a matter of the whim and caprice of the bureaucracy. The court cannot countenance such a state of affairs. Again, as Emily said, this is strong stuff. It's not normal, and it reflects judicial umbrage at agencies that either do not understand or care about complying with the rules of the road established by a coordinate branch of government. The decisions striking down the Trump administration's actions in areas like environmental regulation and immigration have been issued by judges appointed by presidents of both political parties. And so I don't think we're seeing here merely a reflection of judicial ideological opposition to the administration's agenda. It's even-handed in terms of Republican and Democratic appointees taking issue with the approaches that the agencies have engaged in. Our concern is how courts can match the rhetoric we see in cases like this with effective responses to flawed procedures or deficient reasoning. And we identify 4 different kinds of remedies that we think might be capable of stemming the tide of regulatory slop. And let me talk at least about a couple of them. First, fee shifting. Courts can provide incentives for agencies to abide by basic administrative law requirements by awarding attorney's fees to litigants who successfully challenge agency positions. Both the Equal Access to Justice Act and some agency organic statutes include such fee-shifting provisions. And a fee award can have real bite. The Equal Access to Justice Act fee provisions require that awards be paid from the agency's own appropriated funds. General Treasury assets are not available for this purpose. EJA allows fee awards unless the government position was substantially justified. If a court rejects an agency's rule based on flagrant procedural violations or serious substantive deficiencies of the kind that Emily talked about, it generally should not conclude that the government was engaged in substantially justified positions. For example, courts have awarded fees to prevailing litigants in cases involving an unexplained reversal of position or inadequate evidentiary support. For example, in a recent case, a court imposed fees for a flawed effort to delay implementation of an Obama-era immigration rule allowing temporary entry into the United States. The court found that the Department of Homeland Security adopted the delay rule without adhering to the APA's most basic requirements. In particular, DHS relied on an alleged emergency that provided good cause in its view to skip notice and comment procedures. The court rejected the agency's excuses that the original rule would have cost too much or would have caused undue confusion. Neither position, the court said, was substantially justified. Upon initially issuing the rule, for example, DHS had found that the rule would not impose any additional costs on the government, and the agency's change of position simply wasn't supported by the record. We think that the nature of the agency's error, such as whether its conduct was a good faith misapplication of the law or instead reflect a disregard for settled law, should influence application of the substantial justification standard under these fee-shifting statutes. As one court recently put it, the more clearly established are the governing norms, and the more clearly they dictate a result in favor of the private litigant, the less justified it is for the government to pursue or persist in litigation. Second possible remedy that we think could provide the appropriate incentives to comply with rather than ignore procedural and related requirements are nationwide injunctions. Our paper addresses two questions concerning nationwide injunctions, and I'm not going to go into this too deeply because we've got an entire panel on this afternoon. But the two issues we address are, first, whether courts have the authority to issue these kinds of injunctions, and second, if so, when they should exercise that authority. We argue that however one chooses to answer those two questions in general, nationwide injunctions are both authorized and appropriate in the face of fundamental administrative law deficiencies in issuing regulations. We believe that nationwide injunctions can create a strong deterrent against inclinations to flout established principles of administrative law in conducting various agency decision-making processes, but primarily in the rulemaking context. Now, some, including Justice Thomas, have argued that the judicial power under Article 3 doesn't allow nationwide injunctive relief. We don't think current law supports that position. The Supreme Court has remanded some nationwide injunctions, but not because they violated Article 3. Instead, it is determined that they weren't appropriate in the particular circumstances. The lower courts have consistently found adequate authority to issue nationwide injunctions. Now, that may change. A pending Seventh Circuit case provides the opportunity for that court to address the issue directly. So it's possible that the courts will, in the near future, limit or prohibit the issuance of nationwide injunctions. But assuming sufficient constitutional authority, the next question is whether nationwide injunctions are an appropriate remedy in cases involving alleged violations of the Administrative Procedure Act. Here we have cases that go back at least 30 years that provide an affirmative answer. The Ninth Circuit recently, in halting the Trump administration's effort to halt the DACA program, remarked that when a reviewing court determines that agency regulations are unlawful, the ordinary result is that the rules are vacated, not that their application to the individual petitioners is prescribed. The court in that case described nationwide injunctions as commonplace in APA cases. Lower courts in recent cases have even found that invalidation of an agency rule requires the issuance of a nationwide injunction. In issuing a temporary restraining order against a joint DHS-DOJ rule barring asylum for immigrants who enter the country outside a port of entry, a district court recently deemed a nationwide injunction against an invalid rule to be compelled by the text of Section 706 of the APA. Different court reasoned that because an invalid rule was nationwide in scope, so too is the remedy the court must grant under Section 706 of the APA. Assuming sufficient authority, constitutionally and statutorily, for the issuance of nationwide injunctions, the next question is, when should courts exercise their discretion to grant them? Our paper argues that the principal arguments against nationwide injunctions lose much of their force in the context of rulemaking challenges. Further, they provide important benefits that are particularly salient in the rulemaking context. So there are three main arguments against nationwide injunctions that we highlight, which include the need to allow legal issues to percolate up among the lower courts before they are ultimately decided by the Supreme Court, the inclination of or the inducement that nationwide injunctions provide to forum shopping, and the possibility that nationwide injunctions can result in the imposition of conflicting obligations on agencies. For reasons I won't go into now, but that we could discuss in the Q&A, we think that none of those arguments against nationwide injunctions are particularly convincing in the context of decisions that find agencies to have engaged in violations of fundamental administrative procedures in violation of the APA. We conclude by pointing out that nationwide injunctions can have particular benefits in the context of rulemaking violations. One is that they can eliminate competitive advantages that might accrue to regulated entities outside the jurisdiction in which a more limited injunction frees regulated entities up from complying with regulatory obligations. And finally, we think perhaps the most important benefit is that issuance of nationwide injunctions has the capacity to promote rule of law values. They can provide strong deterrents against future flouting of fundamental administrative law norms in connection with efforts to either expand or contract the scope of regulation. If agencies flout the ground rules for proper administrative procedures, it seems appropriate to stop a rulemaking in its tracks everywhere until the agency cures the problem. The two other remedies we discussed, which I'll just mention and then leave at that, are adjusting the nature and specificity of the remedies that courts are willing to provide in response to regulatory slop, and issuance of contempt citations in instances in which agencies violate not only the APA, but court orders directing them to comply with the APA.
Thank you, Rob. Now, to comment on Rob and Emily's paper, we've invited two experienced litigators in questions of constitutional, administrative, and environmental law. Let me introduce first Ashley Parrish. Ashley is a partner in the Washington office of King & Spalding, where he co-leads the firm's national appellate and strategic counsel practice groups. His practice focuses on appellate, administrative, and constitutional law, including energy and environmental litigation. And I like to say Ashley works not just in practice, but in theory. He's written several law review articles on the current state and developments of administrative law. Ashley, thank you for joining us today.
Thank you, Adam. So what I want to say about this paper is I think in many ways this is a really great paper, and there's a lot of things that are good about it. But there's also a lot of ways in which, from my perspective, it falls short. And in fact, I don't think it takes seriously some of the issues that are underlying its thesis. So what I thought I would do is talk about three things that I think are great about the paper, three things that I think where it falls short, and then hopefully use that as a way of suggesting a way of looking at about what the new normal could or should look like. So what are the things that I think are really great about the paper? One is that what's nice about this and refreshing from a lot of ad law papers that you see is it's not abstract legal theory. It's really much more focused on going through the cases in a very sort of practical way. If you take a look at the footnotes, Emily and Rob have done a great service in terms of cataloging all the cases that have come out over the last 2 years. I don't necessarily agree with the way that they describe all those cases, but this is the type of work that we need to see more from in terms of the academy, in terms of really digging into understanding what the case law is happening and how judges are actually deciding cases. Two, neither of them mentioned this morning, but there's a telling point in their paper where they talk about the possibility of something in the way of a common law moment in terms of reforms through the judiciary. And I think that's a really important insight that should be something that they might want to develop more. Obviously, ad law is not common law. Ad law is a species of constitutional law. But if you think about it, when you think about the attributes of common law, they're important to thinking about the attributes of what a good administrative law would look like. So what are those attributes? Well, a few things. One is it's based on logical principles that make you think about how institutions are supposed to interact and work with each other. It's supposed to be derived from experience, not high-level theory. And then most importantly, and I'll get back to this as one of my criticisms, it's supposed to be neutral without any political valence. When you talk about eggshell skull plaintiffs and you think about tort law and contract law, you are not thinking about whether you think you like the administration's policies or you like the tortfeasor's policies. You're just looking at whether the principles get applied in the particular circumstances. And the third thing that I think their paper does implicitly but is really important is it helps explode this myth that any type of reform to administrative law doctrines is naturally an existential threat to modern administrative state. I don't look at Emily and Rob and read their papers and think that they are libertarian ad law advocates. I don't think of them as anti-administrativists. I certainly don't think of them as arguing for a rollback to pre-New Deal principles of administrative law. And yet, if you look at so much of the advocacy or academic work in this area, any type of reform along the lines that Emily and Rob are suggesting is often attacked on those bases. And it really is a myth, and it's important, and I think this paper is very valuable in the sense to try to show that that doesn't make any sense. We can talk about administrative law doctrines without necessarily advocating for radical deregulation or breaking down and getting rid of agencies. So with those three good things, what are my three concerns? And a lot of those have to do with the depth of the analysis and the baseline problem that is baked into the paper. So one is they present a very thin understanding of administrative law and the challenges that it presents. Obviously, their overview is correct in terms of the procedural issues, but the whole game is played in the exceptions to the procedural requirements, not in the procedural requirements themselves. So, for example, you take a look at the principle of notice and comment rulemaking, which applies a central position in their thesis. Everyone agrees that's correct, but then the question is, when do the exceptions apply? And their paper basically starts with the premise that we're looking at the Trump administration is rolling back policies from the Obama administration, but then you have to take a look and say, well, under what circumstances are those rollbacks allowed? If you take a look at the Obama administration, you see that there were great inventions in terms of how to use the good cause exception for notice and comment rulemaking, how often you use guidance documents. That is where all of the debates happen. It's not of a basic question as to whether you comply with notice and comment rulemaking or not. Now, something that harkens back to the earlier panel on this is that I don't think that agencies are engaged in bad faith conduct. I actually do think that agency officials are working through these positions on both administrations in a sort of a good faith effort to do what they think is best. But that ignores the fact that the institutional dynamics are such that the agencies are constantly looking for ways to circumvent the doctrines. And you can't do a serious analysis of what the administrative law doctrines require without getting into an understanding and some theory as to how the exceptions apply and when they're appropriate. It's not just good enough to say that administrative law is a code. There are these 3 rules you have to go through notice and comment rulemaking. They haven't done it, and therefore there's a flouting and flagrant violation. The one example of this that I think is really important to the paper is the question of how do you deal with the problem of midnight rules. So the paper focuses on all of these situations where the Trump administration has delayed the implementation of effective dates of rules. That is a very important issue, and the paper does a great job of highlighting the problem. But the flip side to that is you have to have a question as to what happens when an administration at the end of its term rams through a bunch of midnight rules. Which ones of those are valid? Which ones are not? How are the courts supposed to approach those? How are they not? And the paper glosses over that. In fact, one of the things that you really have to understand is that there was a lot of midnight rules. If we come up with an approach by the judiciary of looking at what to do when the next administration responds, then we have to be happy with that approach, both in terms of what we think about what the Trump administration has done to the Obama midnight rules and also what the next administration will do to the Trump midnight rules. The next thing is I think there's a little bit of a superficial understanding of what is actually happening in this administration. The paper portrays this as the Trump administration is doggedly ignoring ad law principles. There is a good argument that that has happened in some circumstances, and there's a good argument as well that the Trump administration is going in the opposite direction. In fact, there's a sort of a schizophrenia in the administration that on some hands you have some administrators who are very dedicated to rule of law principles and are focused very much on trying to roll back what they perceive as the excesses of the earlier administration. And then on the other hand, on certain policy areas, you see a very concerted effort to interpret their executive power very broadly and aggressively. I don't think it does any service to lump all of that together and ignore the differences between the two of those. I think it's an oversimplification. There is a devotion to rule of law principles in some of these circumstances, and in fact, some of the examples that the paper uses in response to midnight rules are being driven more by rule of law values than they are by any policy values. On the other hand, there's also lots of examples where this administration is continuing. I think one of the earlier panels, Bob made the point of what's going to happen when we see the next administration that, unlike the Trump administration, is more sophisticated, more clever, more careful about how it rolls out its administrative prerogatives. Well, we know what that looks like. That was the Obama administration. Now, we can dispute as to whether you liked what it did or didn't like what it did, or whether you like the Trump administration or dislike, but the reality is that we have been awash in slop on the administrative law side now for many, many years, going back to the Bush administration, the Obama administration, and to suggest that regulatory slop is sort of a new thing that came out of the Trump administration just misunderstands the institutional dynamics and the problems that we have. And then the last concern I have is that I don't think the paper provides a serious analysis of what role the judiciary should have or a theory as to how the judiciary should interplay here. Now, obviously, everybody who thinks about administrative law has to address at one level the point about what Chevron is looking at, what the panel was talking about earlier today, which is how aggressive do you want the judiciary to be? When should they strike down agency exercises of discretion? When they should they be deferential? The paper proceeds on the assumption that every judicial decision is correct, that every striking down of the Trump administration is a correct and a proper application of administrative law, and then it cites good rhetoric in the decisions to support that. Now, I'm fully on board with the project of making courts do more to check the executive branch and to curtail executive branch excesses. But you have to address that issue and come up with some theory that's baked into the doctrines. You can't just assume that the judiciary is doing everything in one direction. So that leads me to sort of, two general observations about how you might think about administrative law and maybe suggestions for ways I would recommend tweaking the paper. So one is that rolling back executive power is a very difficult thing to do. And the reason is I think that there are biases baked into the system. One is it happens on the level of the bureaucracy itself. And the Trump administration, to the extent that it has wanted to pursue, its strategy or policy goals, has underappreciated the difficulties of trying to change the bureaucracy's prerogative. So you put in a few political folks, they want to go ahead and achieve something, and you've got an entire bureaucracy that has spent the last 2, 5, 8, 20 years in this case looking at things in a particular way, and they're not all going to work with you in order to achieve your policy goals. And so you see a lot of these proposed rules or policy statements that are coming out that are not as strong as they could be or need to be in order to survive judicial review. And so one thing is that the bureaucracy itself is going to prevent a rollback of regulatory power, whether that's coming from a Democratic administration or Republican administration. The other thing is I think that there is a sort of a bent in the courts to allowing this to happen. And it has to do a little bit with politics here in the sense that the Democrat appointees traditionally have been more receptive to the idea of bigger, more aggressive assertions of regulatory power. And the Republican appointees have been divided along two dimensions, some who think that we need to be worried about the role of the courts and the courts being too activist, and others being willing to check aggressive administrative power. So if you put all that together, what you realize is that traditionally there has been a bent in the courts against checking regulatory excesses. Now, it may be that, as the paper helpfully points out, that the Trump administration may be changing that dynamic. I take that to be Mike's point on the panel this morning. But again, that is not baked into the system traditionally, and you're going to have to see changing sort of attitudes from the judges, and it's not clear to me whether that's happening or not. And then my final point is that if you're going to think about ad law doctrines in a real helpful way, you need to get rid of the politicization. We need doctrines that are going to be thinking about the institutional principles and are not going to be one-off doctrines that apply just for this administration, just for the policies that you or I may agree with or disagree with. And so my big criticism of the paper, but where I think it could be changed in a way that would really add value, is that this does not need to be about the Trump administration itself. It doesn't have to start with the premise that this is a radical change. It could prove that point if it wanted to, but it could also try to look more deeply at the really great suggestions that the paper has in the back for ad law doctrines and see whether those doctrines really make sense getting applied, not just to this administration, but to any administration, so that the doctrines are more durable. And so if we come out of the Trump administration, the disciplining that is occurring from the courts is not just a political disciplining where everything breaks down, but is instead something that can be used in future administrations regardless of the political valence of any particular problem. I'll leave my comments at that.
Great, thank you very much, Ashley. And our fourth speaker on this panel is David Rivkin. David is a partner in the Washington office of Baker Hostetler, where he co-chairs the firm's appellate and major motions practice. He is a highly experienced litigator, especially on issues of constitutional law, federalism, and administrative law. He was lead outside counsel for 28 states challenging the EPA's Clean Power Plan, and he also represented 26 states challenging the Affordable Care Act's individual mandate. He's one of the nation's leading voices in constitutional and regulatory litigation through the op-eds that he writes often for the Wall Street Journal and other major publications. David, thank you for joining us.
Thank you. Thank you, Adam. I very brief, since we started a bit late, and I want to have some questions, but also because Ashley carried very ably most of my water, I would associate myself both with his praises of the paper as well as his criticisms, and I'll elaborate on a couple of them. I mean, one, I happen to think that the judicial treatment of most of the regulatory emanations of the Trump administration is incredibly politicized. I also happen to think it's qualitatively politicized. I've written a few times about judicial resistance, and I don't think it's an exaggeration. But even before, one of my problems with the state of law and administrative space is that the courts and D.C. Circuit in particular are all in favor of great Chevron deference in some circumstances. When they agree with the policy outcomes, I say they, the panel or the balance of a circuit. D.C. Circuit almost never goes en banc. Clean Power Plan being one example to the contrary. And second, even in that environment, then when the panel or the circuit, am I not speaking loudly enough?
Yeah, I think your mic might be,
No, it's on.
it is on.
Yeah.
Can people hear okay?
All right,
Ashley, would you mind putting your microphone
I'll
in the
try
middle?
to project more. In a situation where they don't like the outcome, it's back to hard look. Okay, this is better. It must be a defective mic. I just make a couple of, random observations about prior practice as far as, for example, extending deadlines. And again, I don't have a comprehensive list, but vividly remember, given my own litigation exposure, that the Obama administration used lots and lots of guidance and something that frankly does not even pass muster as guidance, almost a postage stamp type announcement, particularly in the ACA space, which I was familiar, having been involved both in the original challenge to the constitutionality of individual mandate as well as some other related pieces of litigation. I also vividly recall that they extended repeatedly statutory deadlines, and ladies and gentlemen, not just regulatory deadlines that were sort of adopted by the agency itself in the first instance, but statutorily hardwired statutory deadlines. And in fact, that was one of the key points in the House lawsuit, which I was honored to be affiliated, at least in the beginning, that argued that that level of statutory rewriting actually provides constitutional problems because of Article 2 of it's really rewriting a statute. So, I mean, nobody has entirely clean hands in this respect. But let me also talk a bit more about two other things. Ashley mentioned a point about sort of a bureaucratic entrenchment, and I don't mean in a bad sense, but all regulatory agencies and departments have tremendous level of bureaucratic entrenchment. You have to ask yourself, ladies and gentlemen, from a standpoint of plausibility, how likely is it that a few appointees, and very few because this administration has not been able to staff itself well, to state the obvious, at given agencies and departments have been able to suborn all of the lawyers and all the substantive regulatory experts, EPA and FERC and FDA and SCC. It's not plausible, and we all understand as lawyers and just as logical people, if something is not plausible, it's unlikely to be the case. Second, how likely it is that there's some kind of a gigantic conspiracy among different agencies and departments where what people come to the White House or get summoned by OMB, and I, back in the day, used to participate in efforts to impose integrated regulatory agenda in both Reagan 2 and Bush 41. So what, they have meetings where you have somebody from Ag and somebody from BLM meeting with somebody from EPA, figuring out how they can jointly promote regulatory sloth with respect. That's just not plausible. It's impossible for this to happen. So what we have basically, I think, aside from the fact that the administration is trying to implement a deregulatory agenda, nothing wrong with that, provided you do it correctly, as a matter of basic administrative law principles, and that it consistent with the statutory authority that you've been granted by Congress. I don't think we can criticize them for that. They're trying to put out regulatory product where the career people really do have to validate what's being done. and it's encountering tremendously hostile resistance. So to take me back to my notion of judicial resistance, and particularly the rhetoric being employed, I wonder if this paper would be revisited, let's say a couple of years from now, if a lot of those cases make it to the Supreme Court, if the outcomes are going to be the same. Because, ladies and gentlemen, if you look at the rhetoric by the district courts in both the Fourth and the Ninth Circuit in the context of something euphemistically called the travel ban, you would have seen a lot of bad rhetoric. Talk about insidious motives and racism and all sorts of other unpleasant things. I don't think anybody in this audience would disagree that the Supreme Court were pretty decisively rebuked in a way that is quite rare, both for Fourth and the Ninth Circuit. And I have every confidence that lots of other litigation, whether it's the Emoluments Clause litigation, whether it's asylum challenge to the change in the asylum procedures, or DACA, or XL Pipeline would meet similar fate. I mean, just not to get too granular, but one of the things about XL Pipeline, and Emily can tell me if she disagrees, the record is a little bit different. If you look at actually what happened in the Obama administration, the State Department was perfectly on board with issuing the necessary license. It was a White House decision to overturn that I actually think was, I'd not drilled on it with sufficient level of attention to give you a definitive answer, but my strong hunch is that that decision was administratively and procedurally incorrect. Then you have this administration coming in and fundamentally trying to benefit from the work that was done by the State Department that took several years in the Obama administration, and their biggest sin for which they got excoriated is they did not refresh it. And there's discussion, if you look at the opinion, particularly about how they needed to look at the environmental or greenhouse gas consequences of the pipeline in the New World with different economics, different, particularly different pricing of oil, et cetera, et cetera. And the idea is they have to go for an entire exercise again. That is hardly, to me, an example of regulatory sloth. It is a perfectly legitimate decision to benefit from the regulatory work that was done by the previous administration. And again, whatever the White House decided to do with it should not be impeachable. Actually, I think to me, the even more extreme example of just a hostile judicial resistance that should not be entitled to any validation is the DACA decision, something on which I'm vastly more familiar, having been involved in a bit in the DAPA litigation. To put it very crisply, you have a district court that says that it is fundamentally an example of unreasoned decision-making to rely on the executive branch's view that what has been done by the Obama administration relevant to DACA is unconstitutional. And there's several problems with it, forgetting administrative law. Several problems include the fact that DAPA, but fundamentally, aside from some scoping issues, is not inconsistent. Is entirely the same animal as DACA, has been taken down after, and very much in a motion practice mode in the Fifth Circuit and validated by the Supreme Court. But I also think there's kind of an interesting constitutional problem where you have an Article-free court about reaching the merits of a constitutional determination, which of course they can, says that if the executive decided, even in a fairly summary fashion, that something is unconstitutional, that can be attacked as an administrative law violation. It kind of gives you, to say that Article 3, that to me is worse than the hard look in the statutory context. That is a manifestation of most profound disrespect for the executive prerogatives. So here's Article 2 saying, we think it exceeds our authority, in part, and can spend hours talking about it, because it was not exercise of prosecutorial discretion, ladies and gentlemen. It was an effort to grant benefits to people, which cannot be counted as prosecutorial discretion by any margin. So we have Article 3 basically saying, you know what, we're not going to really get into the merits of it, but we're just going to say you did not do a good enough job in your constitutional analysis or analysis why it's unlawful, and therefore we're going to take it down. So I think we're infected in terms of coming up, which this article tries to do, and it's a worthwhile exercise, with sort of a paradigmatic lessons by the problems that Ashley talked about in terms of what is the right baseline. My view that even prior, quite aside from that, you had tremendously eclectic state of affairs. That's hard to support a unified doctrine when, different panels and different courts use the same labels, but come up with decisions that fundamentally are quite inconsistent because they're really driven by policy, coupled with judicial resistance that has been greeting everything this administration does. So to me, let's just say that the level of noise and fog here is so large that it's very difficult to come up with any clear lessons. Thank you.
Now, Emily and Rob, will give you a moment to respond. If I could just throw one question sort of into the hopper too. Thinking about your paper and your presentation today, there's sort of three categories of agency, of the way agencies approach this. One is sometimes they just get things wrong, just errors. Second, sometimes they strategically push the line, right? Especially in areas where the law is ambiguous or where it seems like the law is in flux. And so you have error, you have line pushing, and then you have slop. And I'm just wondering how to draw lines between those three categories in ways that are useful, not just in hindsight, as a judge is deciding the case or as we're analyzing a judge's decision, but ways that are useful to the agencies themselves ex ante, since your paper focuses on consequences that could flow from agencies falling in one box rather than another. But please feel free to chime in on anything that's come up.
We need to consult for just a moment.
We need the interlude music.
Right.
Well, should I encumber 30 seconds by pointing out?
Just real quick, David, sure.
Yeah, not to be snarky, but if we're talking about administration's overall record, again, not below, but essentially at the highest judicial level, two of the greatest regulatory projects of the Obama administration, Clean Power Plan and CPP, and DAPA both went down in slightly different ways. And I would be surprised if the same thing is going to happen at that level in this administration.
So let me start by both responding to Ashley and hopefully to Adam's question as well. We admit in the paper that we can't read the minds of the agency decision makers. We don't know what their motives were in taking particular actions. And I think in trying to characterize what they've done into one of the categories Adam mentioned, we're relying on two or three different things. First, we're relying upon the characterization of the action by the courts themselves, which is why we highlighted some of what we regard as extreme language coming in out of some of these cases. Second, we made our own determinations of situations in which we thought the law was clear and unambiguous and settled, and when it wasn't. And obviously, different people can look at the same body of law and reach different conclusions, but we used our assessment. And third, I think we can discern something about agency motives in the cases that address fee requests. So if the court decides that there was no substantial justification for an agency decision, that provides some insights into how carefully the agency went about its task. I did quote one case, the BLM waste rule, in which the court said that its conclusion was that the agency, the BLM, intended to eliminate public participation. That was its goal. So that seems to us to be significant. We're not saying that all the cases in which courts have found violations by Trump agencies qualify as slop, but our focus in the paper is on the cases in which we think, or the courts have seemed to indicate that slop occurred, because that's where we think judicial intervention is the most important, and where we think that the courts need to be thinking carefully about what remedies will appropriately rein-in agencies. The other thing I would say in response to Ashley is that I don't think there's been a consistent aversion by the courts to checking executive power. I think there's a balance over time between deference and rigorous oversight, and it shifts. So in the 1970s, you saw the growth of hard-look review, partly at least in response to fears of agency capture. In other eras, the courts have been less concerned about reining in agencies. The final point I would make, and this time in response to David, is that at one point several months ago, we actually did a count of the judges who had participated in cases finding violations by Trump agencies of regulatory procedures. And we looked at it both in the district court and appellate court context. And our finding was that there were either Republican district court judges or Republican Court of Appeals judges that were on the panel in about half of the cases. So our assessment, at least at the time, was that the cases don't reflect acute politicization, but instead these are judges applying neutral principles of administrative law and concluding on the basis of that assessment that violations have occurred.
Just a 10-second observation that unlike President Trump, I don't believe they're Republican judges or Democrat judges. They're just good judges and bad judges. And to me, the fact that somebody was appointed by a Republican president and rose against Trump is not surprising. I mean, if you want to be cynical, plenty of members of the Republican Party in the Trump category. Again, it's very difficult, and I would love to hear from Robert why I'm wrong. If you look at, and again, it's only one example, there would be more. And again, emoluments lawsuit to me, various lawsuits, which I mentioned to Ashley earlier, but I'm stunned. But they've got the stage given how frivolous they are. But if you look at the litigation over the president's executive order on immigration, the level of rhetoric, even vitriol, the district court, and I'm repeating myself, on Fourth and Ninth Circuit, was stunning. They're wrong. They're utterly wrong. I mean, they're wrong not only because I think so and written about it, because the Supreme Court said so. They messed things up in 10 or 15 fundamental ways, including first applying the sort of Lemon versus Kurtz domestic insidious motives paradigm to foreign policy decision-making that is not subject to it at all. And they were wrong pretty much in, think about it, every single point they made, jurisdictionally and merits-wise, was wrong and was taken down by the Supreme Court. So let's not take the position that particularly intermediate and lower court decisions are somehow, you know, an intellectual version of manna from heaven, which we should take at face value.
Do we have any questions from the audience? If you have any, please raise your hand.
Can I respond, Adam? I'd like to respond to this point if I could.
Yeah, sure, but I do want to get to audience questions.
So you know, I think it is extraordinarily difficult, and this is from my own experience litigating as well as clerking at the trial court level, to convince a judge that an agency has so far deviated from the norms that it would use language like that. It is extraordinary precisely because it is so unusual. And I think that when you consider these lower court judges, they see far more agency actions over the course of a given time period. And so the fact that they would make these kinds of very strong comments, I think, is notable and remarkable, regardless of what happens at the Supreme Court level. I think there is something to district courts and circuit courts making such strong statements about agency behavior that is at least one indicator of an agency doing something that the court has not seen before or has not seen to that particular degree. I also just wanted to note that about our choice of emphasis on the Trump administration. That's the title of this of this entire conference, and so that's what we focused on. But I think that both of us have been perfectly willing to criticize other administrations for pushing the line on administrative law. Here again, we're not concerned about, at least from an administrative law perspective, pushing policies in ways that are creative. We know that all administrations do that. we know that that is sort of this claiming of executive power that's been happening over the course of decades. And that's not really what we're concerned with in this particular project. It's these very blatant violations of very strong principles. That's what we're calling slop. And I just want to make sure we're all on the same page there. I think it's, we're not calling slop things that we might disagree with as a policy matter. We're calling slop things that deviate so far from administrative law expectations that it's something new. And by the way, something so new that it prompts courts to make very strongly worded remarks about them.
Great. Thank you, Emily. I see one hand up over here. We'll start here, and then the next question will be, I guess, Michael.
Hi, my name's Elaine Middleman, attorney in private practice, and your position or your argument that the awarding of attorney's fees is an effective deterrent or limitation, I just wonder if that really works. I've had experience with that in Freedom of Information Act cases. And, I mean, the individual attorneys that made the bad arguments or unfounded arguments, they're not paying it out of their pocket. So I've never really, even if it comes out of the agency budget, I don't know that there's any individual accountability or responsibility there.
I guess I don't know about what kind of repercussions individual attorneys have if they lose fee award cases. One would hope that their superiors would say, this is something that we can't allow to continue. We need to be careful to take positions that are justifiable, even if they turn out to be wrong. So the pressure has to come from within the agency as well as from the court.
Next question, Mike Grieva.
Now, I have a question for Emily, maybe, and it's about these, it seems to me a lot of the EPA cases were these suspension of effective date rulings.
It extended across the administrative state to many agencies.
Okay, that's what I wanted to know, because here's my concern, and it's sort of dovetails on something Ashley said. It seems to me in the EPA context, you have to suspend the rules if you want to change them at all in a deregulatory fashion. And the reason is that if you leave the existing rule in place and then spend a year analyzing this stuff, all the investments will have been made and you just lost the benefits that you get from lower compliance costs, right? So no matter how dicey this may be to postpone the date, you just have to do it as a practical matter. I realize why you might want to call it slop. But it sounds to me like a real-world problem that doesn't have a clean administrative law solution in the current environment. And one way to get a handle on it might be to compare those kinds of cases in an environmental context where it comes to where the compliance costs really enter into the equation with stuff outside that context where that consideration doesn't enter into the equation, and if the agencies in those areas also suspend rules without a good reason, yeah, well, then call that slop.
Can I give you an example that might be helpful for you?
Sure.
So this came up, one of the cases that you discussed in the paper, there's a Second Circuit case that has to deal with what happens when an agency is supposed to create a civil penalty and they had to do a catch-up under the statute relating to inflation. And the Obama administration was, and this is not criticizing it, but they were already well behind. And so what happens is at the last minute, they issue the civil penalty update. And when they do it, the Trump administration then comes in and delays the implementation and also says, we're not moving forward. It goes up to the Second Circuit, and in a pretty strong opinion, the Second Circuit says, no, you didn't go through notice and comment rulemaking, and also we're not going to allow you to delay. What the Second Circuit doesn't address is that the reason behind this, although the Trump administration was muted in this, is because the Obama administration engaged in what was a clear procedural violation, what the paper would call a flagrant procedural violation, in the sense that there had been a number of comments made to the agency that the catch-up that was being done on the civil penalty wasn't taking into account the costs and benefits that had been done, and there'd been no response or reasoned explanation as to how to address these real issues. So I think, Mike, this goes directly to it, because as soon as the catch-up comes into place, it has a huge impact on how you develop your fleets going forward. And so the real issue that no one grappled with in any of the opinions was this midnight rule problem, and then the question of how you do go forward. So what the Second Circuit has said is they said, okay, this was an example of regulatory slop, so we're going to strike it down. But they never addressed the prior question, which is whether the existing regulation itself was procedurally invalid, an example of regulatory slop in the first place. And I think, one thing that'd be interesting is I don't know how the courts are supposed to address that issue. I don't think the old administrative law doctrine said, look, we will do this as you can go ahead and delay, and the paper lays this out pretty nicely. You can delay as long as it's not arbitrary and capricious. Well, this gets to David's point that arbitrary and capricious in that context is such an open-ended concept that it really drives based on the judge's policy views as to whether they think it's a good idea or not, because there's lots of situations where they've said, well, good cause exists for not delaying this because of the things that Mike was talking about, or just because of the fact that you think that the earlier rule is procedurally improper and you now want to address questions. But they said in this case, no, that's not within the good cause exception because it's not enough. So that's just a a concrete example, I think, of what Mike's getting at, which is how do you tease that out? I think it's really tough.
Can I, two seconds, just cherry on top. It could be even worse than Mike is suggesting. It's not, ladies and gentlemen, just losing the regulatory benefits. One of the problems is that you have rules that, despite being clearly unlawful, entrench themselves enough because people invest money in it and then become, without even the rule remaining legally valid, become the avatars for this particular idea. And the Obama administration played numerous games with a Clean Power Plan by trying to push it through the, quote, voluntary SIP submittals in a way where, as a political matter, enough people have spent enough money and their competitors have not. So this is a perfect example, really. Think about it. You have an unlawful rule. Let's say it's held to be unlawful, and I think Clean Power Plan is in a category, and yet it's being done because of the failure to suspend implementation.
So I'll respond as well. I think that, so first of all, our paper does address midnight rules in the sense of saying there is a practice that seems to be widely accepted and not remarked upon by the courts of doing short suspensions when a new administration comes in and we have midnight rules within a shorter time frame of the new administration. But when we're talking about rules that have already been in place and sometimes for 6 months to a year, remember we have this huge rulemaking process that's led up to those rules. Whether or not we disagree with whether they should withstand judicial review, that is just the fact of the administrative state. Regulatory certainty has to come from relying on that process. The other point I wanted to make is that although it might be nice for an agency in working toward its objectives to simply be able to suspend rules, the fact of the matter is the agency has to have authority to do that. We do have statutory authority. Section 705 of the APA has certain circumstances under which an agency can do that. The Clean Air Act has certain circumstances under which an agency can do that. Many of the statutory mandates do. What's interesting here is that the courts have found that the agencies have improperly invoked those authorities without providing the basis for doing so. And so although it might be expedient, I think we should want the agencies to follow their statutory mandates. And the remedy there is not to just let them disregard those mandates and have courts permit that to go forward.
Time for one more question, and since this afternoon or today we're cornering the market on George Washington University administrative law professors, last question for Dick Pierce. Dick, wait for the microphone will find you.
As a follow-up to Mike, and actually in a sense a response to David's point on the suspension. Suspension is not going to do the job if you're talking about compliance costs. The Mercury rule and what happened in Michigan versus EPA is the perfect illustration that as you well know, EPA issued the Mercury rule. The Supreme Court rejected it, held it to be unlawful 5-4. And about an hour later, the EPA spokesman came on and said, utterly irrelevant, everybody's complied. And Rob and I actually went to the oral argument on remand at the D.C. Circuit, and sure enough, all but one of the roughly 50 utilities who are affected by it, all but one of them, their lawyers said, yeah, do not get rid of this rule. We have already convinced our state regulators to allow us to recover in our rates the cost of compliance. We have incurred those costs. If you now say that you're going to vacate this rule, we're dead. We're going to get stuck having to bear all of the costs of things. And there's no accident, I think, that it was right after that the Supreme Court issued its unprecedented stay of the Clean Power Plan before any court had an opportunity to, because we now have a problem that we've never grappled with before of the people comply way before any decision is made with respect to the legality of the rule. And so then coming in and saying, well, we're going to suspend a rule that people have already complied with it, that's a real waste. And there's, in a number of these cases, the industry has not been urging that position. States have been urging it, and the industry has said, no, we're happy with just going along with what's already happened.
Rob and Emily, any thoughts on that in conclusion?
I never try and second guess my colleague Dick Pierce. So, no.
Emily, would you like to?
Sometimes I do, but I agree, and we've written this in a paper as well, that regulatory certainty is an issue. That is a problem. So I don't think in our paper we're saying that that's not a problem, but we would like to see agencies follow the rule of law.
Indulge me for 10 seconds. Regulatory certainty, forgive me, is too anodyne of a term. We're talking about very sharp practice. I mean, forget about industry being weaselly and over-compliant. We're talking about EPA, that once they realized that the Clean Power Plan was in trouble, affirmatively went to their peers at states and told them, why don't you submit voluntary SIPs? We don't have time, but I would just tell you in 30 seconds that if something is not a requirement of federal law, you cannot put it in a SIP, okay? You can do something independently at the state level. So lots of game playing. And to me, we're going to talk about the rule of law. That behavior is far more violative of the rule of law and separation of powers, both vertical and horizontal, than any abuse of rule suspension procedures.
Well, Rob and Emily, thank you very much for writing this paper. As I mentioned, all the papers today, including this one, are available on the website. There's a link at the top of the page. Before we thank our speakers, I want to say we'll go straight from this room across the hall for our lunch, our keynote speech from Ambassador Boyden Gray. But please join me in thanking all of our speakers.